you. My name is Emily Early. I am the Associate Director of the Southern Regional Office of the Center for Constitutional Rights. And I will be giving comments on behalf of my organization. Yeah, sure, certainly. So first, before I start with my actual comments, I did want to acknowledge that I stand here before this chamber today on the day after the Day of Trans Visibility, which was yesterday on March 31st, 2025. And so I make these comments in solidarity with our transgender community members in the state of Georgia, both within and outside of the prison walls. The Center for Constitutional Rights has litigated landmark civil rights litigation, including on behalf of transgender incarcerated people, and I would like to refrain from using the word inmate, but transgender incarcerated people, and have built community with those individuals across the South and the nation. So we are therefore able to speak firsthand to the importance of health care for transgender individuals, both within and outside of prison cages. First, I would like to identify our strong opposition to Senate Bill 185, which seeks to deny essential evidence-based medical care to transgender individuals with gender dysphoria in the custody of the Georgia Department of Corrections. In so doing, these bills directly contravene 8th Amendment U.S. constitutional protections, as well as protections under the Americans with Disabilities Act. Gender dysphoria is a recognized medical condition that many transgender people experience. Federal courts, including the 11th Circuit, which is based right here in Atlanta, Georgia, have consistently recognized that gender dysphoria is a serious medical condition requiring individualized, evidence-based medical care under the 8th Amendment. In the context of gender dysphoria, such individualized evidence-based care can include hormone therapy, gender-affirming surgery, and other protections. If adopted, Senate Bill 185 would impose blanket bans on the provision of gender-affirming care to incarcerated people with gender dysphoria, regardless of needs. These blanket bans have repeatedly been found unconstitutional because they show deliberate indifference to the needs of incarcerated people. Even the mere refusal to consider this particular treatment constitutes the very definition of deliberate indifference. I also would like to note that beyond the 8th Amendment, Senate Bill 185 would violate the Americans with Disabilities Act and Section 1557 of the Affordable Care Act. Secondly, I want to note what some of the members here today have noted, that passing Senate Bill 185 would cost many dollars for the state of Georgia. And it appears here there are some legislators who are concerned about fiscal responsibility. So let's talk about it. This Senate bill puts lives at risk, and in so doing would bring constitutional challenges. A recent Atlanta Journal-Constitution article noted that litigation related to transgender people have cost the state of Georgia and its taxpayers $4.1 million since 2014. I would also like to note, most importantly, that the denial of this care creates an increased risk of severe psychological distress and even suicide for transgender incarcerated individuals. I would like to note, in opposition to what the senator said, gender-affirming care is not elective surgery. It is life-saving surgery. In conclusion, I would urge that Senate Bill 185 is not passed, and along with my transgender community members, the Center for Constitutional Rights stands in opposition to any legislation that endangers lives, violates the Constitution and other federal law, and exposes Georgia, a state in which I am a tax-paying member, to unnecessary financial liability. Thank you for your time today.
Thank you.